In the 1990s, Benchmark Capital made a splash among Silicon Valley venture capitalists by investing millions in companies like eBay and Uber, earning billions in returns. However, Benchmark is also famous for Benchmark Capital Partners 4 LP versus Vague, Benchmark's high-profile hostile lawsuit against a company in its portfolio and against Benchmark's fellow investor. Benchmark Capital Partners invested $25 million in Juniper Financial and received Series A and B preferred stock. Juniper's certificate of incorporation entitled shareholders of each series of preferred stock to vote on proposed actions that would materially adversely impact their rights, privileges, and preferences. Another provision required preferred shareholders' consent before Juniper could issue equity senior to or equal to Series A or B preferred stock. Canadian Imperial Bank of Commerce, or CIBC, later invested $145 million and obtained the right to elect 6 of Juniper's 11 directors and Series C preferred stock. This gave CIBC majority voting power and made Benchmark a junior preferred stockholder. As required by Juniper's certificate of incorporation, Benchmark approved this transaction. In 2002, Juniper required additional capital to comply with banking regulations. CIBC agreed to invest another $50 million in exchange for shares of a new preferred stock series. Under Delaware law, this change necessitated amending the certificate of incorporation. Instead, Juniper structured the deal as a merger, which didn't require Benchmark's consent. Under the merger's terms, Juniper would merge into a subsidiary corporation and adopt a new certificate of incorporation. The certificate would authorize Series D preferred stock, which would be senior to Series A and B, and convert Benchmark stock into a new series of junior preferred stock. Series A and B stock would also lose substantial value, reducing ownership by 22% and reducing liquidation preference by $100 million. Benchmark moved for a preliminary injunction to prevent the merger. Benchmark alleged that under Juniper's certificate of incorporation, Juniper's and CIBC's conduct was prohibited and violated Benchmark's fundamental right to vote on corporate actions.